Computer on Alberto Soto. It's an aggravated robbery. Where are we on discovery?
I think I have it all. I've got to review. There's some videos that I've got to review.
Okay. And has an offer been tendered?
It has.
All right, so I'm going to give you a plea deadline, Mr. Soto. And I'm going to set your plea deadline date in September. On that day, you need to let the court know whether or not you're accepting the state's offer. Do you understand? All right, how old are you?
63.
All right, I'm going to set you for September 11th. And on that day, you need to let the court know whether or not you're accepting the state's plea. Of course, if you decide to enter a plea bargain agreement and your counsel wants it placed on the docket sooner than that, then he can do that.
I'll come see you. I've got to look at all the videos. 5 years ago. They won't use it. I'll come see you after look at the videos. I'll come see you look up. Okay.
Today's docket moves fast, and every decision matters. First up, Alberto Soto, charged with aggravated robbery. The judge is checking discovery, confirming there's an offer on the table, and setting a plea deadline, September 11th. That date isn't just a calendar note, it's leverage. Miss it, and the deal can vanish or get worse. You'll hear judges do this to keep cases moving and pressure decisions once evidence is out. Watch how Soto hesitates. His attorney still needs to review video. That's common. Video can make or break negotiations. As we move through this session, notice the judge's style. Firm on procedure, unexpectedly human in tone. And later you'll see how that empathy shapes outcomes when mental health and public safety collide. Question: do you think plea deadlines promote fairness or force rushed choices?
That's it.
Thank you. I'll see.
All right, have a good one. Who's here on Jordan Robbins?
I am, Your Honor.
Mr. Ross. Mr. Ross.
Give me sign.
All right. Hello, everyone.
Good morning, Your Honor.
I recognize all the attorneys. Hello. Oh, there's somebody new here. Who's new here?
Yes, Your Honor. Rick Foster. I represent one of the physicians whose documents been requested.
Okay,
Dr.
so,
Rodriguez.
all right, and who is the prosecutor on this case?
I am Your Honor. It was not my motion. The hospital.
Oh, well, okay. So, all right, everyone, please whisper. So, other than this hearing that we're about to have with regards to the subpoena, is there any other discovery that the state has in their possession that you need?
Your Honor, seconds before they were called up, I was advising that there was some kind of records that came in on Friday. I think it might be related to this subpoena. I haven't had a chance to review it. I was going to run upstairs and grab it.
All right, so let's see if that's it, because then you will have already turned it over to the state, if that's what it is.
We didn't turn over anything, Judge. We're asking to quash the subpoena.
Well, no, she's saying
Well, let me
that
go
she's
check.
received
It might be
something.
something separate.
On the form we got on e-discovery, it just said notice of additional discovery, but that it was checkmarked like medical records. I think it was handwritten in, and I didn't have a chance yet to talk with them about what that is.
So
We were also awaiting the remainder of the pediatrician records of the child, so it could be that too.
All right, so let's see what it is in case it is this, because sometimes people accidentally do things. And if they've accidentally already turned it over, then that's a problem not on my plate. So she's gonna go check that, then I'll call you all back up as soon as she sees what records they are.
Yes, ma'am.
Did you send? They could be. Oh, yes. But it's all of that. So we're gonna like put on my chair. Yes, we're looking for that.
All right, are the parties ready on Nelda Rios? All right, court is calling 2022 CR 11792 State of Texas versus Nelda Rios. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Albert Chidas for Ms. Rios.
are you Nelda Rios?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nelda Rios who was placed on deferred adjudication in 2022 CR 11792 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on April 19, 2023 for a period of 2 years? Is that you?
I do gotta say, I don't remember. I do have a head injury, but
All right, she doesn't remember that she was placed on deferred adjudication. Do you know when she had this head injury? Was it before or after she was
it
placed on
was-
probation?
It was before, Judge, and she did remember earlier when we were talking. It's something that I was talking with the state and with probation about. She does have some deficits. She goes to Center for Healthcare Services for treatment.
Nelda Rios is facing a motion to revoke deferred adjudication, but she reports a head injury and can't remember being on probation. That's a red flag. Revocation requires willful violations. If memory and mental health are in play, the court must slow down and reassess.
All right, so do y'all think she's competent?
She has been, this is the first, she says she doesn't remember being on probation. And we had actually talked about trying to help her because she was homeless. There's some issues that came up. She's on SSI for her head injury, but she lost her ID. And when that happened, she got evicted from housing. So we could work something out with Haven for Hope, get them to help her get her ID temporarily.
So are you all looking to withdraw the motion and alternate main conditions?
Judge, we thought that it would be better to come and have the motion heard, but again, that's up to you.
I think it would be best probably to withdraw and alternate main conditions.
Your Honor, we were looking to maybe getting some evaluations done while she was in custody.
Ah. So what evaluations are we looking at?
The TAP
Mental
and
health.
mental health evaluation.
My only concern is I understand y'all want to do that in custody, but she's telling me she doesn't remember signing conditions or being on probation. She doesn't have a place to stay?
She was living under a bridge when she was arrested.
All right. So here's my question for you. One or two things can happen. You can remain in custody. While in custody,
Listen closely. The judge suggests a motion for new trial to route Rios to mental health court, even though they usually take pretrial cases. That's unusual. It signals a priority. Stabilize first, punish second. Ask yourself, is this compassion or a necessary path to justice?
you will be evaluated. We can reset the motion to revoke, and you can be evaluated for the mental health caseload. Would you like to do that?
I already know that I'm not capable of, that I cannot, like you have to tell me all over again if I didn't understand it.
All right, let's do this. Why don't we see whether or not the mental health court will accept her? I know they only do pretrial diversions, but if nobody's going to object to it, I'm willing to do a motion for new trial. And we can start all over, because I see I'm not the person who took this plea. So if you would check with mental health court to see if they'll accept her, because that may be the better placement for her, because I think she's going to need one-on-one care. So if you'll check with mental health court and let them know, and you'll have to let them know that she's currently on deferred adjudication, but I'm willing, if nobody objects, to hear a motion for new trial, grant the motion for new trial, because the key is to get her the mental health treatment. And this is a possession less than a gram case.
Yes, Judge.
Okay. So is everybody on board with that?
Yes, Judge.
Yes, Judge.
All right, so what I'm going to do is I'm going to reset you for 2 weeks. There may not be anything completed in 2 weeks' time because mental health court will have to interview you, but I just don't want to lose track of you in the system. Okay? Do you have any questions?
No.
All right, do you have any family?
I don't. I have that. Sometimes I don't even have money to buy me a meal.
Okay,
I haven't been able to have a bank account with Bank of America, but because I don't have an ID, because when I got arrested, I was in my apartment. And it's a long story. But I had gotten a better criminal trespassing in my apartment, and that's why I got arrested for this case. I'm sorry for it.
oh no,
We came to court and went through all this process, but being out, I don't even have money to buy me something to eat or pay for a motel room because of everything I've lost. And I got arrested at the motel. And I know that I have had issues with mental health since I was 10 years old.
okay. All right, so we're going to give you a 2-week reset. And that's just so I won't lose track of you. So now we have a plan. We're going to try to get you in the mental health court and probation. Could you see about the mental health case evaluation while she's in custody, just in case that doesn't work out?
Yes, sure.
All right, is there anything else?
No, Your
All right, Ms. Ferguson, I need a 2-week reset on Nelda Rios, please. You're welcome. All right, so we're going to put it down for court. Why?
Yes, ma'am. I apologize. It won't happen again. I had difficulty this morning. Trying to get my bearing on where it was at. Okay.
I'm sorry, what?
I had difficulty this morning getting my bearing on where the courtroom was at.
Okay, all right, so now you know where it
Yes,
is.
ma'am.
All right.
It'll never happen again.
All right, so where are we on this case?
It's a first setting, Judge. I've spoken to my client. There seem to be some parole issues that we need to get to the bottom of before we can negotiate any kind of offer.
Okay,
So we just need time to figure that stuff out.
all right. And so he has a parole hearing.
No, Judge, he's on parole. They haven't issued a violation. They haven't issued a blue warrant, anything like that. So we want to kind of tiptoe to make sure that whatever deal we take isn't a moot point.
Okay. All right, Ms. Ferguson, on this case, give me a 45-day reset. You can put it down as discovery.
I can do September 28th.
All right, September 28th, just get the reset form, then you're excused. If for any reason he has a parole hearing or something on that date, just let the court know.
I appreciate it, Judge. Thank you.
All right, you're welcome. Right after this.
Good morning.
Good morning. All right, so, Mr. Morrison, come up, please. All right, so if you, so the last time we were here, there was some discovery on mental health issues,
So, Your Honor,
and then it was supposed to be a referral to mental health court.
that, I apologize, Your Honor, I didn't know about that update.
I go to the VA for mental health, and I have been since 2008. While I was active duty
Okay.
and after as well.
Yes, Your Honor, and we're trying to obtain that information so that we can present it for the state for possible mitigation.
All right. So is this going to be a referral to mental health court or no? Because the last time we were here, there was supposed to be a referral to mental health court. And this happened in July. So has that been done?
Not, no, Your Honor. I need, if I can reapproach Your Honor and get better information, but I don't.
All right, so I can tell you all that was supposed to be done, the referral to mental health court. Now, if he's a veteran, if you all want to see if Veterans Treatments Court is willing to accept him, you can also see that. And if that's the case, then we'll have someone from Veterans Treatment Court come down now.
Okay, Your Honor. If I can just step back.
Sure. Okay,
Thank you, Your Honor.
no problem. All right, Robbins. All right, are you all ready to go on the record?
Yes, ma'am.
All right, the court is calling 2022 CR 11724, State of Texas versus Jordan Robbins. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Amy Owen for the defense.
All right. And the other two attorneys who are here?
Yes, Judge. Brandon Wong for Alexander Reed.
All right, so everybody, please do not whisper because the court reporter cannot hear. So,
Brandon Wong for Alexander Reed.
Yes, Your Honor. Rick Foster here for Dr. Javier Rodriguez.
all right. So before we get into the reason for the other two attorneys being present, I want to make sure that you have all the discovery from the state that the state has in its possession.
That the state has in its possession, I believe so, Your Honor. I do not know if that's what is in their possession is comprehensive of the order of the court of what was ordered to be turned over. I had not looked at that yet, since we do have a final discovery, I believe, setting, I think it's on the 24th.
It's the 24th.
So this was set for the motion to quash today, and we already have a discovery setting set on the 24th.
Okay. All right. So let's go over the motion then. And I have a first amended motion.
Yes, Judge. Do you need a copy?
Oh, I have this. And did you file a motion as well, or is
I did
this?
not, Your Honor. I found out about it yesterday, but we're subject to this motion because we're the doctor, one of the doctors that is being asked to produce records for Mr. Wong's client, Ms. Reed.
All right.
And Your Honor,
So defense.
Your Honor, so as the court's aware, we have argued, sort of argued this prior to the court, and we're not on a fishing expedition to for all of her medical records, but what we are interested in and looking for are medical records that occur between January 1st of 2022 up through January 31st of 2022.
All right. Do y'all want to write this down, what she's asking for?
I can get it.
Okay.
Let Mr. Wong know. So there's American Health Imaging on January 6th, 2022, January 18th with Dr. Nivra Beta, January 21st with Dr. Malhorta, and January 31st with North Central Baptist Hospital ER. And then we know that the outcry in this case is February 8th and 9th. And the reason we're asking for this, Your Honor, is that the mother of the complainant suffers from a frontal traumatic brain injury. We know that occurred in 2012. And those, because of, without revealing too much of our defensive strategy in this case, there's information contained within the case file of the civil discovery and within the court-ordered psychological evaluation by Dr. Richard Tice that gives us reason to believe that there could be exculpatory information contained within mother's medical records, mother's outcry witness in this case. And we believe that what is contained within those records could be exculpatory. We're asking for the court to do it. We're not asking for them to be turned over. We're asking if the court would do an in-camera review of these records to see if there's anything relevant to this case in terms of symptoms and diagnoses of what happened within the 30 days of outcry. And that's what we're requesting.
All right. And state,
Yes.
are you planning on calling this witness as an outcry witness or calling this witness at all?
She would be the outcry witness, Your Honor. And we had a hearing previously on this, and our position as to why we did not feel that these records were necessary was because she is just the outcry witness. She's not, the allegations themselves come from the child. The child said these allegations multiple times. And it's just very attenuated from how there could be any relevancy. It's kind of well, there might be something in there. And we don't know that there is, and it's the state's view that it's outside our duties to provide, which is why they chose to subpoena independently.
Well, the court's question, this brain injury, did it occur before or after the alleged outcry?
Before.
About 10 years before.
All right.
Judge, obviously, they're asking for my client's protected HIPAA information. It's just clearly a fishing expedition. The subpoena is defective on its face. They actually didn't even follow the procedure. They didn't serve my client. They never served my client with the actual subpoena for any of the records they're asking for. The subpoena is incorrect because it doesn't even list her name correctly, her birthday correctly. So again, no one can even provide the information they want because again, it's just defective on its face.
But obviously, you know,
Obviously, I know about it, but and
'Cause
that's
you're
why we're
here.
here. But the reality is, Your Honor, as the state said, none of this information is remotely relevant. They're just trying to simply fish. My client, again, she's one of many outcry witnesses that have heard the child's statement. She's not the victim. She's not saying this happened to her.
but this is the person that the state is calling as an outcry.
I get it, Judge. But again, she's not the only one. And then they're still able to have my client on the stand, ask her whatever they want. You know, that is, we all know that is how it works. And so they're able to get whatever information. They're trying to link something that happened 10 years ago and saying, well, now she got some sort of mental handicap where she is now convincing her child. You know, that's their strategy. It's not even a secret. They're trying to say that she has influenced her child to say that these allegations have occurred to her. It's a stretch to say the least, Your Honor. And so again, it's just harassment on part of, you know, they're just making my client spend countless dollars and time fighting this thing. She has nothing to do with it. All she did, she made a report and that's it. She's out of it. And so again, for them to now see all of her records, you know, now they're cutting it down. Originally it was her entire medical file, her entire medical records. And I understand they just want a couple visits here and there. But again, Your Honor, my client's still going to have to produce them. It's a hassle. There is nothing relevant that's going to come from this. And they're hearing it's possibly exculpatory. They don't know. There's nothing other than just their speculation. It's just pure speculation that they can come up here and say, you know, we just want to harass this lady to get these records just so we might be able to strengthen our defense. And again, as the prosecution has said, it's just not relevant.
Okay. And do you have an argument?
Your Honor, we just merely support the patient, Dr. Rodriguez's patient, Ms. Reed. It's her record. She doesn't want to produce them. We don't want to produce them. And it sounds like
Defense wants a tight slice of the mother's medical records around the outcry window, arguing potential exculpatory value. The judge orders an in-camera review. She alone will read the records and decide relevance. This is the balance: privacy protections versus a defendant's right to evidence.
it sounds like from the summary that was given by defense counsel, they're not even asking for Dr. Rodriguez's records at this point. Is that correct? Even though it's okay, so we have a subpoena, but you know, so we need protection from that subpoena. I can file a separate motion, or
Well,
we
I
can
mean-
agree on the record today that it's, or as the court determines, that subpoena
Well,
is
just
withdrawn.
1 second, because I'd like to
Oh, yes,
cut to
yes,
the
Your Honor.
point.
Okay.
So this attorney, his patient, or his doctor,
Yes, Your Honor.
are there any records that you want from this doctor?
I don't believe so, Your Honor. However, since we don't have any, we don't know if it references, you know, any type of diagnosis or treatment that's referred back to that. But these specifically, what I read are what we're requesting.
All right. So here's the thing. Number one, he's saying that the subpoena is improper on its face because it doesn't have the correct name, the correct date of birth. I think we all know who it is and who we're here for. If you want to make another trip down to the courthouse and they can correct the name and the date of birth, they can do that. But I can tell you what my ruling is going to be. What my ruling is going to be is, yes, I need to see it in camera inspection, and I will make a determination of whether it's relevant or not. If I deem that it's not relevant from the in-camera inspection, then that will be the end of it. But I can't make a determination on whether or not a record is relevant or not until I see it. So just listen to everybody's argument. I've listened to your argument, but I need to see what it is. So she is telling me she has narrowed it down to this specific thing. And my understanding from both sides, or let me make it clear to everybody, that's the specific thing. We're not going outside of that specific thing. So counsel, if there is something that you feel that the attorney who's here today, that there's something that they have, let them know specifically what it is. And then if you all will present it to the court, not to the state, not to the defense, just present it to me, I will review it. And then I will make a determination whether it's relevant or not. And my understanding from defense, they're no longer asking for the entirety of the record, which I would think the entirety of the record would not be relevant. But the specific part she's asking for, I'll review them and make a decision on that. So first question, are you going to want me to rule that on its face because it has the wrong date of birth, wrong name? And just
On its
say,
face, Judge, honestly, yes, Your Honor, they need to refile it.
all right, so
And then I'll
this is-
ask my client, once they serve a proper subpoena to provide said documents and then, because I understand what your ruling is, but
Mhm.
obviously I can't agree to release her records when it's just not been properly done.
all right, so when will you have your subpoena ready?
Today.
All right, so she's gonna have her subpoena ready today. So while she's getting her subpoena ready, if y'all can get those records ready for the time frame, if you give them the time frame, it's not, I read very quickly. It's not gonna take me long to do it and to review everything.
And Your Honor, I think the other issue would be that in order to for anybody to get the records, that the court would need to order Mr. Wong's client to sign a HIPAA release to the actual entities to be able to release the records to the court.
I'm not gonna order her to sign a HIPAA release,
Okay,
so.
so once we get the subpoena and then the court, we would direct the entity to send the records directly to the court.
Yes,
Okay,
and then if you all are able to get the records directly to make the process move quicker and bring them to me, and I will review them in camera. And as I said before, when I review things in camera, I really review them in camera. Defense doesn't see it, state doesn't see it, her client's not going to see it. I'll be the only person who's seeing it.
May I address?
Sure.
Your Honor, pursuant to HIPAA and the CFRs underneath that, we have, if it's a third-party subpoena, to be able to release the records, we need to be ordered to produce those records. And then there needs to be provisions that they're prohibited from using the records and disclosing them outside the litigation, and they're required to return the records upon the conclusion of the proceedings. And so
Here's my thing.
may I pass something up to the court?
Sure. But you may pass it,
Yeah.
but I will tell you, I don't believe in crossing bridges until they're built.
Yes.
So the first thing we need to do is, if you all will confer on the date she's speaking about,
Yes.
and then she can have her new subpoena and you all just get the records prepared for the court. And if you all can have the records and bring them to me, because sometimes when things are mailed to the court, it goes to 6 different places. People don't read 187 4th floor with a suite number. So it goes to different places. And so nobody else will read it, just me. If y'all will bring it to me, and if you could put it in a sealed envelope that says judge only on it, nobody else will open it. The staff would not open it. It'll go specifically to me.
And can we go ahead and submit an agreed order on how those records are being tendered up to you, because you've directed us to do it?
Sure.
And
If you all
put it
can,
with the documents?
yes.
Okay, you okay
Yes.
with that?
yeah, sounds
Okay.
great.
All right. And then she'll get the subpoena. But I will tell you, our next court date in this court for discovery matters are August 24th.
Yes.
So if you all can have all those records to me before August 24th, that would be great. If not, I can read it on August 24th, but I just like to have leisure reading before that date.
Okay,
All right. So August 24th, does anybody need anything else?
No, Your Honor.
no, Your
All
Honor.
right. And if there's not any objections from the defense, if you all want to appear by Zoom, you're more than welcome to appear by Zoom, as long as I have the records to review in camera. Is there going to be any objection?
No, ma'am.
All right. So if you all would like to appear by Zoom, just let the court know. The court coordinator will give you the Zoom link.
Right.
That'll work. Thank you, Judge.
All right.
Good.
Thank you.
Thank you, Your Honor. May we be seated?
Yes.
Thank you.
And Caroline, can you make sure that's in on the form for August 24th? Luis Camacho.
President Council, Your Honor.
Hello.
Here is Mr. Camacho.
All right, where are we on this case?
Judge, defense is asking us to look into some other issues. It's something to do with the bar, where this all happened and possible records of the security guard. We're gonna try and reach out to someone, but
All right, so what discovery is it actually that's needed?
It's any potential disciplinary or formal complaints filed against the security officer who is the complaining witness in this case. There were specific details provided in the discovery I do have so far, where there potentially may have been other instances of misconduct by the security officer. So I'm asking the state to look into that and provide that to me.
All right, we're going to recall this on September 11th.
If I may, Your Honor.
Yes.
On that particular day, I do have a doctor's appointment with my wife. She is going to be potentially going into labor.
So which day would you prefer in September? 18th?
That would probably be better. If it doesn't happen that day, I should be available on the 18th.
All right,
I appreciate it.
Caroline, could you give them a reset form on Camacho for discovery September 18th? All right, thank
Thank you,
you.
Judge.
Thanks for dressing appropriately for court. Are the parties ready on Christopher Morrison or no? All right, Trinidad Velasquez. Hello, good morning. So in this case, do you have all the discovery?
I believe all discovery has been uploaded to e-discovery for counsel.
All right, has an offer been tendered?
An offer has been tendered, Your Honor. We are still conferring regarding a possible referral to mental health court.
All right,
or,
when
I'm
it's-
sorry, to Veterans Court, I'm sorry, Your Honor.
all right. Bashan, can you have Herman perhaps come down? All right, just have a seat in the box and we'll see if we can get somebody from Veterans Treatment Court down to see if he's even eligible.
All right, may I be excused to go to another court?
Yes,
Thank you.
and so that's for Morrison and Velasquez. Sean Griffin.
Good morning, Judge.
Good morning. Why are we here today?
Just a quick bond hearing, Judge.
Okay,
We're just looking to do tracking only.
all right, who's the prosecutor? Court is calling 2023 CR 6161, state is Texas versus Sean Griffin. Could I have parties announced for the record for the state?
Travis Banks for the state of Texas.
Defense?
Samuel Lyles for defense.
All right, we're here for a motion to modify bond conditions. They're requesting tracking only. Do you have an objection, state?
Without further information, yes.
All right, have you conferred?
Judge, we have conferred. He's currently on partial because he does have a full-time job, but he just actually graduated from barber school.
Yes.
And so he's looking to do tracking only to be basically a barber that can travel around and do haircuts, because currently he's just in his mom's bathroom doing the haircuts. Good. And I do have one witness, Judge.
All right, if you'll call your witness.
Takesha Harris.
All right, and you want to put your drink down?
Yeah, sorry.
Sure, no problem. Everyone needs to whisper. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Takesha Harris.
All right, defense.
Ms. Harris, you know why we're here. What's your relationship with Sean Griffin?
I have his 5th child.
I'm sorry,
I
what?
have a child with him.
Okay.
And how many children does he have?
He has 5.
And in regards to his financial situation and the children, can you just tell the judge what's going on?
Well, ever since this has started, it has put a dent on everything. My daughter goes to IDEA, so they have no buses, so to pick up and drop off has been hard because I have no one to do it, so I haven't been able to really work. Financially wise, he hasn't been able to really do anything because he can't go anywhere, provide how he used to. I have photos of how much of an active father he is to all of his kids. He has 4 with someone else, and then he has 1 with me. He gets his kids all the time. We just had them. It's just, we haven't been getting them a lot because he can't go anywhere, and I don't want them just to be sitting in the house. But I just need help with being a parent, and most of this for him to be there for his kid, because he missed my daughter's graduation. My daughter had surgery. He couldn't go. He missed his oldest son graduation to go to high school. So just want help. He's not a violent person.
And Ms. Harris, in regards to his children, does he financially support them?
Yes,
And how is the GPS hindering his ability for the children?
this is the first school year. He didn't get to get anything for the kid because we've been having to pay for things. So he won't go back to jail because he was behind on his bail's bond and stuff like that. And me and his mom have been doing as much as we could.
And
We
what
don't
are
have
his
it.
sources of income?
He was working. He had just got promoted at his job at security, but he lost that. So he just started working at Toyota and barber. He's a really good barber. That's where most of the money was coming from. And he just passed his test, so. But there's so much that he can do.
So he's a licensed barber. Is he traveling around? How is he doing haircuts?
Right now, he was doing them in his mom's restroom because he can't go anywhere. And he really can't cut at school that much anymore because he graduated.
And if he's able to travel, is that going to help him make more money for his children?
Yes, and to be there for them to pick up from school or anything.
Thank you, Ms. Harris. No more questions, Your Honor.
Any questions?
Yes, what hours does he need to be able to travel to?
That, it's just depends, different people call different times and, oh, I'm so sorry. Different people call at different times, and with helping with my daughter from school, she has to be at school at 7:45 and school ends at 3:45. But we get there a little early because she goes to IDEA and they don't have no school buses, so the lines be long. It just really depends on who calls and asks him. Sometimes he goes in the middle of the night, sometimes it's during the day. It's just he makes more traveling because there's not really a lot of barber that travels.
So he wants to be able to travel around even in the middle of the night to cut hair.
Well, right now he works overnight and then he works during the day also. He works 2 weeks in the morning, 2 weeks at night, and then it switches back 2 weeks in the morning, 2 weeks at night. But my main thing is to be there for his kids also.
So he's a licensed barber. Is he traveling around? How is he doing haircuts?
Right now, he was doing them in his mom's restroom because he can't go anywhere. And he really can't cut at school that much anymore because he graduated.
And if he's able to travel, is that going to help him make more money for his children?
Yes, and because I'm literally a single parent and his mom works out of school too, so she works at a different district, so her hours are the same as the hours that I need help with.
And do you two reside in the same household or?
Not anymore, no. He lives with his mom because of,
And so you also want him to be able to take the children to school and get
Yes.
home from school.
he missed my daughter's graduation and my daughter had surgery, a major surgery, and I have to literally do it alone and take care of her because he couldn't be there to help.
Okay, no further questions.
All right, anything else?
No, Your Honor.
All right, thank you.
Okay.
All right, you can come back here. All right, any other witnesses?
No, Your Honor.
All right, the court will hear argument.
Your Honor, in regards to his situation, he's a very involved parent. He has 5 children. He's trying to be there for them, not just financially, but to take them to basketball practice, make sure they're in school, doctor's appointments, whatever it is. In addition, he does have a full-time job at the Toyota plant, but to support 5 children, it's not exactly making ends meet. So he needs to be able to travel as a licensed barber so he can go around and do his haircuts and make extra money.
State?
Your Honor, with regard to the school participation, the state does have no objection to him, helping out with taking the kids to school and that sort of thing. With regard to the mobile barber business, during business hours, that sounds like a fine activity to be doing. I am a little concerned that the witness did say that even in the middle of the night, sometimes he'll be out cutting hair. I don't think the court should approve that, but doing barber business during normal business hours, I don't think the state objects to that.
All right, so I will allow you to work upon proof of employment and work hours and to attend all children's school and medical appointments. Your work hour, it's going to be a curfew for that unless it's Toyota. And I think, what time would you like the curfew?
I mean, for the barbering business, I guess 6 p.m. would maybe reasonable.
Yes, are you able to do that?
Yes, ma'am.
All right, work hour curfew as a barber. Will be 6 p.m.
And Judge, could we just note, because I've talked to pretrial in situations like this before, and they want to see an LLC or some DBA on behalf, but he's going to be a sole proprietor because it's his own business. There's no way to put a note that he's a licensed barber. And he can...
If you would speak to the coordinator, she'll have pretrial services officer zoom in. If you know who is pretrial services officer, we'll have them zoom in, and so they'll understand the court's order.
Okay, perfect. Thank you,
All
Judge.
right, so just talk to the court coordinator about that, and she'll have them zoom in.
Yes, Your Honor.
All right, is there anything else?
No, Your Honor. Thank you, Judge.
You're welcome. Hi, thank you. Oh, it is. These two gentlemen. So one is in custody and one is on bond.
Okay, Judge. I'll take a look.
All right, thank you. Nicholas Cornelius. And then after that, it will be Griselda Rosales. All right, who is the prosecutor on this case? Court is calling 2021 CR 0835, State of Texas versus Nicholas Cornelius. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas. And Jackson Lindsay on behalf of Mr. Cornelius, Judge.
Are you Mr. Cornelius?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Cornelius, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Judge, we're going with the lesser included offense robbery.
Any objection?
No.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with or at least the state is proceeding on the lesser included offense of robbery? That's a second degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to accept your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge, I believe he's competent.
Do you believe he's currently, yes, do you believe he was legally sane at the time of the offense? Mr. Cornelius, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of robbery, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph, did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and no contact with Jose Aguilar. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers exhibit 1 in all its applicants. No objection.
All right. And state, have you been in contact with the complainant?
So we have been in contact with the complainant, Your Honor. There were other co-defendants in this case. One of them also did have the charge reduced to robbery and was given to her.
All right, thank you. Oh, you may be excused to continue to confer. Mr. Cornelius, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes,
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, we're waiving the advice.
All right, anything you wish to say on behalf of your client?
Just so the court is aware, Judge.
All right, so everyone, please whisper in the box. We're on the record. Yes.
Thank you, Judge. Briefly, my client had court in the Winnebago District Court back on May 31st of 2022. That day, he was arrested by the U.S. Marshals for a federal charge of being a person under indictment in possession of firearms.
Okay.
He spent 15 months in custody awaiting that charge. We worked out a deal in federal court for a plea bargain, accepting his ability to appeal that sentence because that particular statute is being challenged in the upper courts right now, 922N. 18 USC 922N. So because he was denied bond, he was in a position where he ultimately pled guilty because he did have the firearms. That explains why we took so long to come back to this court. He's here now, Judge. He's been offered deferred adjudication from the state. He's accepted it pursuant to the court's approval. As part of this federal judgment, after serving 15 months, he was placed on supervised release for 3 years, which I'm asking the court to run that concurrent with this federal case. And that in the event, unlikely event, I believe, he would be picked up on a violation of probation in this court, that any time served in federal court awaiting disposition of that case be credited towards any time given in that case, in the event he's sentenced.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right, are you employed?
Yes, ma'am.
What do you do?
Pack and moving, Apple moving service.
Okay. All right, this is what the court is going to do. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Jose Aguilar. There's to be restitution, if any, to FedEx. Regular reporting. By Zoom or in person. Regular UAs. 200 hours of community service restitution. There's going to be parenting classes. Once he completes parenting classes, that will be deemed to be satisfied. Field visits. 1 time per month for 3 months. And probation. If you all want to check with the federal government and see how their field visits are, you may not have to do any if they're doing them as well. So if you could check with them. There's to be no contact with Aubrey Reed, Aubreyreed, Charlie James Ray Perkins, Amari, Emari, Lafel, Lafel, Freeman, Freeman. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Probation, is there anything else he needs? Yes. All right, is there anything else you need from the court to have black excellence in your life?
I'm out. Judge, maybe run this concurrent with this federal cause number. I can give you that cause number.
All right, concurrent with what's the number?
SA:22-CR-294.
All right, the court will run it concurrent.
Thank you, Judge.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
No, ma'am.
All right, we can go off the record. Here's the thing. From here on out, in this court, whatever you do in your life while you're on probation, you need to ask yourself 2 questions. One, is what I'm doing something that could potentially result in me being revoked and sentenced to prison for 20 years?
Griffin asks to swap GPS limits for tracking only so he can work as a licensed barber and parent 5 kids. The court lands on a compromise. School runs and medical visits allowed, barbering with a 6 p.m. curfew and proof of employment. Bond isn't just rules, it's calibration.